Petitioner's motion to expedite consideration of the petition for a writ of certiorari before judgment is granted, and respondent is directed to file a response to the petition on or before 4 p.m. Eastern Time on Wednesday, December 20th, 2023. Welcome to Law and Society. This was a reading of the Supreme Court granting consideration of the petition to grant a certiorari. They haven't granted the certiorari yet. A certiorari is a certification process that in which four Supreme Court justices review a case and assess whether they can take the case. If they are granted certiorari by four justices, the case goes to the full court for review. So Jack Smith has asked the Supreme Court to expedite the appeal of Donald Trump on the immunity grounds. So what I'll do is I will read out some parts of the filing, and primarily the filing that talks about the writ of certiorari. I won't go into the memorandum with the other, the substantive case. So the indictment, I'm going to read you portions now. The indictment further alleges that respondent aimed at accomplishing the conspiracy's objectives in 5 ways: using deceit towards state officials to subvert the legitimate election results in those states, using deceit to organize fraudulent slates of electors in 7 targeted states and cause them to send false certificates to Congress, leveraging the Department of Justice to use deceit to have state officials replace the legitimate electoral slate of electors who would have cast their votes for respondent, attempting to enlist the vice president to fraudulently alter the election results during the certification on January 6, 2021, and directing supporters to the Capitol to obstruct the proceeding and exploiting the violence and chaos that transpired at the U.S. Capitol on January 6, 2021. The district court denied the respondent's presidential immunity claim and his related double jeopardy claim. The court concluded that the Constitution's text, structure, and history support the conclusion that respondent may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office. The district court reasoned that several features of the impeachment judgment clause undercut the respondent's assertion that it confirms any immunity from criminal prosecution. Holding a former president criminally accountable, the district court observed, is essential to fulfilling our constitutional promise of equal justice under the law, and further, the public interest in an ongoing criminal prosecution. The district court also found nothing in history to justify the absolute immunity that respondents sought. The court discerned no evidence that the founding fathers understood the Constitution to bestow such immunity, and the executive branch had expressly and repeatedly concluded that a former president was subject to criminal prosecution. President Ford's pardon of former President Nixon aimed to prevent the latter's potential criminal prosecution, demonstrating that respondents' view of presidential immunity for criminal liability stands at odds with his predecessors in the Oval Office. And now, Jack Smith goes into the reason why the Supreme Court should be granting the petition. A cornerstone of our constitutional order is that no person is above the law. The force of that principle is the zenith where, as here, a grand jury has accused a former president of committing federal crimes to subvert the peaceful transfer of power to his lawfully elected successor. Nothing could be more vital to our democracy than that a president who abuses the electoral system to remain in office is held accountable for criminal conduct. The Constitution's text, structure, and history lend no support to that novel claim. Neither the separation of powers nor respondent's acquittal in impeachment proceedings lifts him above the reach of federal criminal law. And respondent has moved to stay all of the proceedings in the district court while his appeal is pending. It is of paramount public importance that the respondent's claims of immunity be resolved as expeditiously as possible, and if respondent is not immune, that he receive a fair and speedy trial on these charges. The public, respondent, and the government are entitled to nothing less. Yet, if this case proceeds through the ordinary and even a highly expedited appellate process, it is unclear whether this court would be able to hear and resolve the threshold immunity issues during its current term. For that reason, the government seeks a writ of certiorari for judgment to accord this court an opportunity to grant review now and ensure that it can timely resolve the important immunity question presented here. The United States recognizes that this is an extraordinary request. This is an extraordinary case. The court should grant certiorari and set a briefing schedule that would permit this case to be argued and resolved as promptly as possible. A writ of certiorari before judgment is appropriate when the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination in its court. Supreme Court Rule 11. This case involves a paradigmatic issue of imperative public importance: the amenability of criminal prosecution of a former president of the United States for conduct undertaken during his presidency. It requires no extended discussion to confirm that this case, involving charges that respondents sought to thwart the peaceful transfer of power through violations of federal criminal law, is at the apex of public importance. The charges implicate a central tenet of our democracy, and the charges allege that respondent conspired to transgress the law in manifold ways by intentionally using fraudulent means to obstruct the presidential electoral process, by obstructing constitutionally prescribed processes in Congress for counting electoral votes, and by seeking to deprive millions of voters of their electoral choice for president. The district court set this trial for March 4, 2024, to ensure fulfillment of the public's interest in seeing this case resolved in a timely manner. The public interest, in a broad sense, as well as the constitutional guarantee of a speedy trial, commands prompt disposition of criminal charges. Vindicating that public interest in this case requires immediate resolution of the immunity question to permit the trial to occur on an appropriate timetable. If appellate review of the decision below were to proceed through ordinary process in the Court of Appeals, the pace of the review may not result in a decision for many months. Even if the decision arrives sooner, the timing of such a decision might prevent this court, meaning the Supreme Court, from hearing and deciding the case this term. Precedent supports expeditious action. When government sought certiorari before in the United States v. Nixon, the court granted petition and resolved the constitutional question expeditiously so that trial could begin as scheduled. The decision issued 16 days later and was issued 16 days later, and the trial began when it was supposed to. While no precedent supports respondents' claim as to a former president's criminal immunity, The government acknowledged that this court has not addressed a comparable claim. And this is a quintessential example of an important question of federal law that has not been but should be settled by this court. In recent years, this court has often granted certiorari before judgment in cases of imperative public importance that warranted an immediate determination by this court. It should follow the same course here. As noted above, the district court has scheduled the March 4, 2024 trial, and respondent has appealed. Given the uncertain timing of appellate proceedings in the ordinary case, including potential requests of rehearing en banc, certiorari before judgment is appropriate now to allow the court to provide the prompt and definitive resolution that the issues presented here require. If the court grants review, the government respectfully requests that it establish a schedule for briefing and argument that would allow the case to be resolved as promptly as possible. And if the court elects not to review this case at this time, it may wish to note that the Court of Appeals should proceed with sufficient dispatch to permit the Supreme Court to hear this case promptly during its currently scheduled argument sessions for this term. So that's the part where Jack Smith argues that this certiorari should be granted and why the certiorari should be granted. In my previous episode, I talked to you about the appellate process and how the appellate process could delay. And today's filing, Jack Smith echoes that exact concern. And because of that concern, he has taken the court to the Supreme Court. And now the Supreme Court has asked for a response by the respondents by December 20th on the issue of whether to grant certiorari or not. If they do grant certiorari, the substantive issue of the immunity, a former POTUS's immunity, criminal immunity, will be heard by the full Supreme Court, and an order will be handed down that will be binding, meaning the lower courts would have to follow it. So if they say there is governmental immunity for a former president with, there's criminal immunity, then this case goes away. But if there's no civil immunity for a respondent in this case, in governmental, there shouldn't be any criminal immunity either. And so the Jack Smith has added the memorandum for the lower court's argument with his motion to expedite and to ask for certiorari. And that's, I'm not going to read you that whole thing. Suffices to say, now we wait until December 20th to see what Donald Trump submits, and then we see whether the Supreme Court grants certiorari or not. It is my belief that the Supreme Court will grant certiorari. I even jumped the gun on that for a second and was put back in my place because I thought they had granted certiorari. They are hearing. They have granted to hear whether they would grant certiorari or not. So with that, that's all I have to say. So if you're new to my channel, please like and subscribe and share. And if you're returning, hey, Derek, thank you for being here. Thank you for being here. And please share this information. Take care.